It's 11:30. I will let the defense do their closing. I would encourage the defense to take the advice the state did and not use the entire hour and a half. It's really not necessary. And 1.5 hours is an absolute hard stop. I'm going to go through lunch. I'm going to tell the jury that I've ordered them lunch. Let's bring them in. All right, jury's coming in. Silence in the gallery. All right, the jury back. For the jury, we're going to work into lunch. The defense is going to do their closing. The state will have an opportunity to do rebuttal. I've ordered lunch. Lunch will be waiting for you. So we're going to work into lunch, get the closings done, and get the case to 12 of you to deliberate. Defense can proceed.
Good morning, members of the jury. Robert Kennedy once said, "The glory of justice and the majesty of law are created not just by the Constitution, not by the courts, nor by the officers of the law, nor by the lawyers, but by the men and women who constitute our society, who are the protectors of the law, as they are themselves protected by the law." Members of the jury, it's been over a week now. And as the state has pointed out, I've seen you very active and engaged in this case. You've been taking notes. And this is a traumatic situation, for both parties that's involved in this case. This case has been filled with emotions on both sides of this case. And, we really just thank you for just, keeping an open mind as we go through the process. Now, the state just talked about, when we talked about the other side of the story. Remember that? The defense in this case has established everything that we said we would show you on the other side. The state didn't come up and talk about a wallet. You never heard about a wallet in this case. We told you that the crime scene was contaminated. We told you that seconds afterwards, there was tampering of evidence in this case. We promised that we would show it to you. That promise did not come back void. Now we're talking about a wallet all of a sudden. Now, 1.5 years later, there's an explanation for a wallet. Now, the truth of the matter is, no party here knows exactly what took place on September 22nd of 2020, because the state has not satisfied and filled their burden. They haven't proved anything beyond a reasonable doubt. What they've shown is theories. They haven't proved anything beyond a reasonable doubt. They just came up and said, oh, he didn't have a weapon. And then, it was a weapon in his pocket. And then they talk about, it was a folded knife in the right pocket. Oh, no big deal. As if it takes so long for a folded knife to become a threat. Here's the knife. It's folded. Could go in a pocket very easily. Here the knife is extended. How long does it take for the knife to go from being extended to being folded? Let's find out. Less than a second. Now it's folded. Now, just at the onset here, I want to discuss a couple things with you. You've heard a lot of testimony in this case, and this is a case that, as you can see, just with the coverage of this case, it evokes a lot of passion. This case it's a precedent-setting case. This is a rare case that has been presented to you where this time there's an African-American man who's now using self-defense against a Caucasian man. You don't see that every day. And he's not just anybody. The evidence is shown he's not just anybody. He's somebody that's well respected in this community and has been referred to by many as a prominent immigration lawyer. So, when you're faced with those circumstances, Now, I want to be the first to tell you, we put Mr. Edgecombe on the stand yesterday. Now, we thought about not putting him up for a couple reasons. Number one is because the state hadn't even proven their burden to begin with. Mr. Edgecombe insisted, I want to tell my story. We promised you in the opening that we would have him up to tell his story. But Mr. Edgecombe was scared. The same fear that he had after he'd been hunted down by these two individuals. That same fear where he described as being the next Ahmaud Arbery. The same fear he had with turning himself into law enforcement and wondering if he could be taken into custody safely, as he described what he recalled from Sandra Bland. That same fear he exhibited on this stand yesterday. Now the state would say, oh, we can't trust this testimony. Well, let's talk about his testimony. Mr. Edgecombe, we felt it necessary to get out all the bad facts right away. We told you in opening, we're gonna talk about the good, the bad, and the ugly. I told you at the very beginning of the opening statement, there's three things. Mr. Edgecombe was not supposed to have a gun. He temporarily, not supposed to be in possession of a firearm at the time. We told you that. He's taking responsibility for that. You heard about bail jumping charges in this case. He's taking responsibility. We also told you that Mr. Edgecombe did in fact punch Mr. Clarendon. He never disputed it. You heard him come on the stand and take responsibility for it. You heard him come on this stand and say that if I could do this over, yeah, I was upset. Yes, I was infuriated. But if I had another chance to do this, I would simply accept being hit by a vehicle, thrown into another, and being called a nigger. Those were his words on direct examination. What else did he admit on direct examination? See, it's not easy. This is the first time that Mr. Edgecombe ever been sat in a witness box before. This is the first time he ever been charged with murder. These are serious charges. Who wouldn't be afraid? Especially in the city of Milwaukee, where you have amongst the largest incarceration rate for African American men. Of course, he had every right to be afraid. Now, you might say, well, why was his demeanor a little bit different with me than he was with the state? Let's talk about that. Well, first, I will tell you, when I first met Mr. Edgecombe, he was a little bit guarded even with me.
Objection, Your Honor. As to defense counsel testifying as
Sustained.
not in front of the jury.
Sustained.
Mr. Edgecombe.
Watch Johnson hyperbole.
Mr. Edgecombe has had fears. He going before a government where it's not popular to use that type of force against another race. Mr. Edgecombe, he was afraid of being tripped up. Now with me, he's a little bit more comfortable. He's got a chance to know myself, an attorney of mine, over the pendency of this case. It's a little bit different. But he understood that one wrong answer could potentially get him convicted of murder. So we talked about before that he has a diagnosis of attention deficit disorder. We don't want to play that up. He's a very intelligent person, but it's real. And sometimes the effects of that show itself when you're in a very highly stressful situation. Attorney Hubner, great attorney. There's times that both of us have had to exert a certain amount of aggression or a certain amount of assertiveness to get the evidence in this case. The evidence, it doesn't just present itself. Sometimes you have to dig, you have to keep going. And there were times in this case, if you recall, Mr. Edgecombe, was trying to complete a sentence and was not allowed to. He wanted a simple yes or no. Well, every answer does not result in a yes or no answer, but that's the position he was in yesterday. Now, Mr. Edgecombe testified. You heard him say. Now, Mr. Edgecombe had, if you recall on cross-examination, he talked about, you know, the gun went off after he lunged at me. You recall that? He said it a couple times. Mr. Edgecombe believes that he's already made it clear that he shot Mr. Clement. He intended to shoot Mr. Clement to stop a threat. He did not, however, intend to kill someone. There's a big difference. So every question that discussed homicide or murder or blowing someone's brains out, of course, Mr. Edgecombe was taken back by that and did not want to answer a question in a certain way, so he kept resorting to, my actions were in self-defense. I acted in self-defense. Then he went and he understood that part of your consideration, members of the jury, is to consider the reasonableness of his actions. We all know he shot Mr. Clement. We established that in opening statements. The question for you, though, is the reasonableness of those actions. Part of determining the reasonableness of Mr. Edgecombe's actions is when did he decide to shoot Mr. Clement? At what point did he decide to shoot Mr. Clement? That's the question. That goes to reasonableness. So Mr. Edgecombe kept reiterating, the shot went off at the time that he lunged at me. He's trying to explain to you the reasonableness of what he felt was at the time that he shot. He's not trying to imply that, oh, this was just an accident. He's only trying to discuss the time frame. The shot went off after he lunged at me. Now, Mr. Edgecombe's no lawyer, not a doctor. He was on his way. I mean, he had just a few credits away from a psychology degree. He had a bright future. But we all articulate ourselves differently. Members of the jury, we're diverse people. The words I might say to describe something might not be the words that you might use. So we don't discredit Mr. Edgecombe based off of wordplay. So when he says, oh, you know, the gunshot goes off after he lunged at me, then he's followed by a very good aggressive question by the state that says, oh, so it was an accident. So you killed him and it was an accident. Well, let's just think about that for a minute. Can you answer that in a yes or no? If he said yes, he just, you know, that's what he ultimately said. Because he doesn't want to say, I intentionally killed Mr. Clement. Because remember, he never intentionally tried to kill anyone. He only intentionally tried to stop a threat. Techniques used by a good prosecutor. Please don't hold that against Mr. Edgecombe. Go back to your notes. See what Mr. Edgecombe testified to on direct examination. On direct examination, did Mr. Edgecombe not tell you? I went down the stairs, then I went home. I put the gun there. Go to your notes. Did Mr. Edgecombe not tell you when I asked him? I was right here, and I asked Mr. Edgecombe, did you give the police your ID at the time you were apprehended in Kentucky? Mr. Edgecombe said what on direct examination? No. On direct examination, I asked him, did you give them a fake name? Did you give the Kentucky Police Department a fake name? What did Mr. Edgecombe say? Yes. I asked on direct, why did you do so? Go to your notes. He explained it. He explained it. Then on direct examination, I also asked Mr. Edgecombe, did the Milwaukee Police Department detectives come down and when they asked you about something happening in Milwaukee, did you say, what happened in Milwaukee? Mr. Edgecombe said, yes, I said that. Members of the jury, there was a follow-up question to that. Why did you say that? When Mr. Edgecombe was comfortable, he answered the questions. When he's comfortable, he did not hesitate to not answer one question. Fear is real. Attention deficit disorder is a disability. It's real. Anxiety is real. Being charged with murder are real feelings. Every other witness that stepped up here, if they had a bad day on the stand, if we got some information out or they answered a question the way that they might not have wanted to, you know what happens to them? Nothing. They go home. They have dinner, they get up to the next day, and that's it. Not when you're the defendant in a murder case. That answer could determine whether you're convicted or not. That's the reality. That's why before he feels like he's getting tricked up on something, can you ask the question again? Now, we talked a lot about, the fear. We talked a lot about, what happened on the stand, and these are red herrings. It's a red herring. It's a distraction. So now let's talk about the state's burden of proof. Let's discuss it. They have the burden. As the court has appropriately indicated, the defense doesn't have to prove anything. Though everything we came up and talked about, we showed you. In opening, we told you. We've shown that. So let's talk about the burden of proof. Now, as you see, the state has that burden. There's a lot of different thoughts that you might have. When you get different parts of evidence, it might lean you one way or not. So it's important to understand that it's only the state that has the burden of proving something beyond a reasonable doubt. It can't be probably, it can't be maybe. So let's go through what the state's witnesses showed us. In fact, we actually like the state's witnesses. In fact, we would have, there's a couple of people that was noticed on the state's list that we thought were great witnesses, and we called them ourselves. A lot of proving reasonable doubt can be established just off the state's witnesses. For example, let's go to the first slide. So we discussed reasonable doubt. Again, it's not probably guilty. It's not guilt likely. None of that. All that will result in not guilty. If it's not beyond a reasonable doubt, it's not guilty. And at the end of this defense presentation, we're going to ask that you find Mr. Edgecombe guilty on all counts. We started with first degree intentional. You're going to see some lower charges that have been added. We're going to ask that all charges that you find Mr. Edgecombe not guilty. Let's go to the first slide. Mr. Rotrell Cameron. Now, this is probably one of the most memorable witnesses in this case. He's the only witness that was brought in with the orange jumpsuit. Mr. Rotrell Cameron, let's go over the highlights of his testimony. He stated that the incident was cold-blooded. He stated that the shooting appeared to be cold-blooded. That's why the state liked his testimony. That's what he was brought in for. Mr. Cameron testified that he was going to pick up his subpoena.
All right, we need a break. Counsel, back to your table. We need a break. Let's take the jury out. I need the gallery cleared right now. Bail's out. Everybody out. Quietly and professionally, but out. Off the record. Edgecombe, it's 12:15. I discussed the situation with the attorneys. Unfortunately, one of the jurors, about half an hour ago, maybe 20 minutes ago, felt a bit lightheaded. She does not feel well. I'm going to make her, and the lawyers are stipulating to this, the alternate. We have 12. I believe we should continue, finish the closings, and let those 12 deliberate. Either side object to that plan?
No.
Great. All right, I'll bring in the 12. The juror, I'm not sure of her number, we'll make a record of that later. It's a younger white female, will be excused as the alternate, given that she's not feeling well. The remaining 12 will come in. All right, the jury's coming in. Everyone can remain seated, please. All right, the jury's back. Welcome back, everybody. The juror that you saw that was not feeling well, the lawyers and I have agreed she's the alternate. We excused her. There's 12 of you. The 12 of you will deliberate. My bailiffs have checked on her. She's fine. She felt a little lightheaded. She indicated it might have been something she ate, but she feels fine. She's doing better. So we'll continue. Defense can, if you remember where you were, pick up where you left off, but go ahead, counsel.
So members of the jury, we were talking about the state's burden of proof in this case. And just a quick reminder, quick review is that the defense in this case doesn't have a burden, have no burden whatsoever. And we discussed prior to the break that majority of the reasonable doubt that could be established in this case can actually come directly from the state's own witnesses. So we're going to go through the testimony of the witnesses in this case, and we're going to show it to you. We're going to show you reasonable doubt in that they cannot satisfy this burden of proof. Let's go to the first slide. So the first witness, we discussed Rotrell Cameron. Well, he was one of the state's first witnesses. And what Rotrell Cameron testified to is he described witnessing the shooting occurred, and he described it as the words being cold-blooded. Cold-blooded. He used those words. Now, that's why the state liked Mr. Cameron. That's why they wanted, that's why he's essentially almost their star witness. He's the one witness who could testify outside of Ms. Clearman, outside of Mr. Edgecombe, who had witnessed the last two incidents that occurred. So we know there was 3 incidents. We know that something started this. Mr. Cameron witnessed the last 2. He described the last final incident as being, it was cold-blooded. Now, what was interesting about Mr. Cameron's testimony is that immediately after he described it as being cold-blooded, he testified that the defendant appeared to be in shock afterwards. Those were his words. He said he appeared to be shocked. I don't know how many cold-blooded, heartless, violent killers are shocked after they shoot somebody intentionally. But that was Mr. Cameron's testimony. So what happened? You seen the state, after they worked hard to get this witness here, you seen the state jump up and start trying to impeach their own star witness. You remember? Do you recall? Mr. Huebner was right here. He said, well, you never said anything about him being in shock before. You didn't tell the detective, the officer, that when he was on the phone with you in the patrol car, you didn't say he was shocked. Remember that? Go look in your notes. That's not consistent with being a cold-blooded killer, the way they're trying to make Mr. Edgecombe to be. This is their witness. We didn't call him. Let's look at what else Mr. Cameron told us. He admitted after the punch, he used a very key word. Mr. Cameron used a very key word when he described it. He was asked, did Mr. Edgecombe, after he punched Mr. Clement, did he withdraw from that confrontation? He said, yes. He was asked, was he a threat at that point? He said, no. He admitted that Mr. Edgecombe withdrew once he got on his bike from that confrontation. Now, members of the jury, you're going to see that word withdraw or withdrawal again. You're going to see it in the jury instructions. It's going to be under the provocation. See, the state wants you to believe that, oh, well, let's see who started it. If you started it, you can't claim self-defense because you're the aggressor. Well, they forget about a very important word. It's called withdrawal. See, once you terminate and you provide notice to the party that you've acted aggressively with, you can regain your right to self-defense. That's the law. You're going to see it in the jury instructions. Mr. Cameron, their star witness, testified to this. What else did we get from Mr. Cameron? He admitted that Theodore appeared afraid when he turned the corner. He almost fell trying to evade him on the bike. Cold-blooded killer, violent, heartless, appearing afraid? Those don't even go together. This is their witness. They caught him on this stand. We asked him. So when he turned the corner, he appeared afraid. I said, when he went from the bike lane and jumped the car, he said, well, he fell. He definitely appeared afraid at that point. When he continued going on the sidewalk, and when he went into this little stairway, he appeared afraid then too. He told you he was trying to go down the stairs. This is their witness. This is their witness. It doesn't matter how loud Mr. Huebner comes up and how passionate he is. These are the facts. Check your notes. Now, the state just came up and tried to make a big deal. Now, let's just get this straight. We started and we said this is a very tragic situation. Our heart goes out to the Clement family. This is a situation that escalated and it should not have. At some point, Mr. Edgecombe was responsible for a part of this incident. He punched Mr. Clement. He got upset because racial slurs was used based off of his testimony, or rather it was a swear word, whatever the case is. At some point, Mr. Edgecombe got upset. We know that. But at the end of the day, this situation escalated, and we're not trying to go back and forth and do victim blaming. That's not what this is about. As the state tries to indicate, they talked about, well, they said, oh, the wife, Ms. Clement, she was not hysterical, she wasn't acting a certain way. We, the defense counsel, never said that. You want to know who said that? Their star witness. Let's go back to Mr. Cameron. Mr. Cameron is who said that. Mr. Cameron described the wife's demeanor as calm, but he was hysterical. That's what he said. That's what their witness said. He said, I thought that was a bit unusual because I was hysterical. I was going crazy. I was on the phone with 911, but she seemed to be calm. We didn't put that at issue. Their witness did. So again, let's just put that for the record. Now, as we talk about different things that happen in this case, it is not to, blame anybody, but it's to show that Mr. Edgecombe cannot be proven guilty beyond a reasonable doubt. That's the purpose. We're showing all these things that appear suspicious. There's a lot of questions that are unanswered in this case. And if the questions are unanswered, they have not fulfilled this burden. This is not about, we've never met Ms. Clement. I don't know her. Either have you. So we don't know what she would or would not have done. We're not sitting there just trying to kill someone. All we're saying is that the possibility exists. And we don't know. So Mr. Edgecombe should not be convicted of murder because we have a lack of knowledge in that area. That's why we go through all these different aspects of the case that seem a bit suspicious or that warrant more explanation. Or we talk about the failures of law enforcement in this case, and the investigators, to not be thorough. And because of the lack of thoroughness, that's why these questions remain. And that's why, ladies and gentlemen of the jury, Mr. Edgecombe should be found not guilty on every single charge. Let's go to the next slide. This is Officer Patrick Tibnan. Now, the state called Officer Tibnan. Officer Tibnan testified that initially
Your Honor, state did not call Officer Tibnan. Defense did.
Gotcha. All right, my apologies. If the defense called Officer Tibnan, my apologies. So with the testimony that was elicited from Officer Tibnan, he initially stated it was 2 potential witnesses that he believed wanted to give statements. But what did the video show? Remember? Remember the end of the video of his body cam? When he goes and he asks another officer and he says, "Hey, I see a guy standing over there. I see a guy standing over there. He looks like he might have seen something. Should I talk to him?" The first officer says, we were wrapping up whatever he says, it was inaudible. So then he goes to Officer Mihalik, who's coming down. And Officer Mihalik, he says, "Hey, I see a guy over there. Looks like he has some information that could, in this case, I want to go talk to him." Officer Mihalik says, "Fuck that. We got enough. Fuck that. We got enough. We got the wife. We got this 911 caller. We got this young gentleman right here, which I believe was Jose Perez. He was in the video. We got enough." That's the evidence in this case. How? You never have enough of anything in a homicide investigation. Mr. Clement deserves a full investigation. Guess who else deserves a full investigation? Mr. Edgecombe. He deserves all the facts as well. You don't just jump to theories and rush to judgment. And at any point, this is 43 minutes after the incident occurred on the stairwell. 43 minutes later, you got an officer telling Officer Tibnan, we got enough. Members of the jury, you proved guilt beyond a reasonable doubt. You didn't do a thorough investigation. Then the evidence showed with Officer Tibnan that he was instructed to turn his body cam off. He asked, "Hey, are you live? Are you live?" Think that's a fair assertion as to are you recording? Is your body cam recording? Think that's a fair deduction? And what Officer Tibnan does next is he says, "Should I cut it?" He said, "Yeah." At that point, that's the end of Officer Tibnan's body cam. We don't know what happened after that. This is all reasonable doubt, members of the jury. Next slide. So now we come to Detective Tyler Kirkhope. Now, Officer Kirkhope, he agreed that any time an item is removed from a scene, from a crime scene, it is compromised. That's what he told you. He talked about the duty of a first arriving officer to preserve the scene preservation. He talked about that's why you see the yellow tape immediately after a scene, because you don't want to have evidence tampered with. You don't want that crime scene to be compromised. Members of the jury, it's no longer an allegation as to whether an item was removed in this case. I told you in opening, we're gonna prove it. We've done that. Whether the admission was of a wallet or whatever the item was, An item was removed and the crime scene has now been compromised. That's just it. So how do you prove guilt beyond a reasonable doubt? We don't know. Again, we're not making any, listen, we have to put out theories. We don't know. I don't know any of these individuals of these parties. So, Detective Kirkvold said that no citizen, under any circumstance, should remove anything from a crime scene. It should be further investigated. Detective Kirkvold also said he can't confirm or deny whether an item was removed or placed at the crime scene. This is the lead detective. So what do? We go back to the burden of proof board. This is the detective. Can't prove anything beyond a reasonable doubt when your lead detective can't confirm or deny whether an item was removed or placed at the crime scene. We don't know. Again, it's not an accusation, we just don't know. We don't have enough information. Detective Kirkvold also testified that he doesn't know where the first incident happened and he didn't follow up. He also admitted when asked, I just thought that was unbelievable. The lead detective on the case cannot tell us where precisely the first incident occurred where Mr. Edgecombe and the Clearmans had an altercation of some sort involving a vehicle. We don't know. The lead detective does not know. But then we asked the detective, we said, how long would it have taken you to ask Ms. Clearman to get in a vehicle with you and have her show you precisely this is where it happened at? Sounds reasonable? He admitted it would have only taken...
Your Honor, mischaracterizes the statement that was by Detective Alvarado, not Detective Kirkvold.
That may be the case, but it's closings. Let's move on. Go ahead.
Stated it would take 5 to 10 minutes. 5 to 10 minutes to have confirmed. So we wouldn't be here a year and a half later, members of the jury, still not knowing precisely and exactly where even the first incident occurred. 5 to 10 minutes. They didn't do it on September 22nd of 2020. They didn't do it on September 23rd. And we asked, have you done it? Have you ever done it? In a year and a half that this case has been going on? No. That shows you the quality of the investigation in this case. Mr. Clearman deserved better. Mr. Edgecombe deserved better. And that is another reason why the state cannot satisfy their burden of proof. Next slide. So members of the jury, we now remember where Detective Alexander Klabundy was called to the stand. I believe, if I'm not mistaken, that he was the state's first witness, I believe. And he testified that the knife found in Mr. Clearman's pocket was a folding knife with a serrated blade, perhaps up to 10 inches in length. He confirmed that police never submitted the knife for DNA fingerprint testing. Here's the knife. You heard in testimony that other items like bottles, eyeglasses, those items clearly would make it really hard to exert deadly force toward anybody, but those items were tested. Why was the knife not tested? He also confirmed that the White Claw can was never tested as well. The White Claw can that was in a back door, that can was never tested either. We don't know whose hands were on these items. And that, ladies and gentlemen of the jury, brings us back to our board. Burden of proof. Can't prove guilt beyond a reasonable doubt. Now, the state came up here and they talked about, well, his hands were bleeding. And his hands were, he came off the door, he got punched, he touched his face at some point. So that's kind of trying to indicate whether or not, the knife should have blood or anything like that. But remember this exhibit, Defense 11? This is the pants pocket of Mr. Clearman. You see specks of something. Could be blood, could be dirt. We don't know. We just don't know. Now, does the state have resources to make that determination so we don't have to guess? Of course they do. This pants pocket could have been submitted to DNA as well. But it wasn't. And that, members of the jury, brings us back to the board again. Proving guilt beyond a reasonable doubt. We wouldn't have to speculate if the state would have done their job. Next slide. Now, it brings us to Ms. Evangelina Clearman. And again, our heart goes out to the Clearman family. Now, let me just get a couple things clear. Just get a couple things clear. We understand that after, seeing or being involved in such a traumatic experience, one would tend to be distraught. That's fair. You don't know how you would react in a situation like that, especially involving a loved one. That's fair. Now, the issues that we bring are not to any way, blame, victim blaming or anything like that, as we just discussed. But when there's conduct which is somewhat suspect or it brings or begs a question, we have to present it. We have to bring it to your attention so that you, the trier of fact, can determine whether something has been proved beyond a reasonable doubt. So one thing I can say is that, there's several things in this testimony that, we have questions about, some of which, like I said, could be reasonable under the circumstances. But the state has not proven beyond a reasonable doubt. Her testimony is simply not reliable. It's just not, and we're gonna go through why. So it doesn't mean that, she's a bad person. It doesn't mean that, there's any type of issue. But it just means that simply because of those circumstances, her testimony is not reliable. Let's start. The first thing that she recalls saying, she said her husband said, "What the heck?" That was her recollection. She said, "What the heck?" Ms. Clearman went and did media interviews, and she told those journalists that Mr. Clearman said, "What the heck?" Fair. Now, on the body cam, we showed you in evidence Ms. Clearman clearly saying, "What the fuck?" Now, the issue is, it just goes to the reliability. This could indicate a tendency to water down a situation that was a little more severe than what it actually was. There could have been some things said that was beyond what the fuck, as Mr. Edgecombe claims in this case. But that tendency, we don't know. Ms. Clearman also says she was looking at Theo in her rearview mirror. She also says she doesn't recall her husband opening a door after being punched by Mr. Edgecombe. Now, again, when you have a traumatic situation, I'm sure when Mr. Edgecombe came up, and I'm sure the state is going to come up, he came up, he violently punched him in the face, blah, blah, blah. We know that. But we have to now assess her recollection now and the credibility, because you members of the jury have to determine the veracity and the weight that you're going to credit her testimony. So what she testified to is that she doesn't recall the door opening when Mr. Clearman looking to exit, likely to proceed after Mr. Edgecombe at that point. Now, generally when you open the door, especially at night, your lights are on, right? Her lights were on because you're gonna see later that those same headlights were going toward Mr. Edgecombe. But when the lights were on, you know, when you open the door, some cars, you know, the interior light comes on. That would further be an indication that that door was open. Sometimes you might hear some type of noise when a door opens, a chime, if you will. So she doesn't recall that. And again, I'm sure it was a traumatic situation, but again, we have to learn, we have to determine how much weight. Some credit should be given to her testimony, absolutely. But how much do we give it? And that's where we go back to the board. This is how the state is improving their case. Guilt beyond a reasonable doubt? No. So let's go to the next slide. She said her husband told her to turn the corner because he wanted to talk to Mr. Edgecombe. But the video shows that she likely made an illegal turn from the middle lane to make that right turn. She also admits that Mr. Edgecombe was no longer a threat when he got back on the bike to leave. That's important. That's important. I don't know if you recall when we stopped the video, and you probably were wondering, like, what are they doing? And why is this point being driven so hard? Because we wanted to make sure that she agreed that Mr. Edgecombe was not a threat to her at the time he punched and got back on his bike. And that's why we asked questions. He said, so he's in front of you, right? Yes. You see the back of him, correct? Yes. And at this point, he's not a threat to you. She said, yes. That's important for a couple reasons. Number one, it shows that Mr. Edgecombe retreated, or the word that you're going to see in the jury instructions, he withdrew. That's the word that the state is not going to want you to pay much attention to. They want you to gloss over that fact. Withdrawal. That's what it is. He got on the back, he got on his bike, he proceeded forward, he turned the corner. That's notice that's imputed to the Clearmans at that point. No doubt about it. The next point is she also admitted that she could have kept driving straight to go home. I don't know if you guys, members of the jury, I don't know if you recall, I don't see it here now, but we had a board that we referenced at a couple times in the trial. And in that board, we look, you turn right here, what's these locations here? And we asked, okay, so which way is home? And she testified that, yeah, this is the board. Thank you. So you remember the board, but we asked which way is home. And here's Brady Street. Here's the intersection where the X is. One of the witnesses during the course of this trial placed the X at that intersection. That's important. And she testified that home was straight. That would be the direction to go home. So Mr. Edgecombe had already made his right turn already. He already made his right turn. That's not a dispute. You've seen it in video. She decided to go take a right turn after Mr. Edgecombe, likely under direction of Mr. Clearman. So when the state comes up and they talk about, he's a cold-blooded killer. He's a cold-blooded. He's violent. He's all of this. Mr. Edgecombe, at this point now, he punched somebody. And the question you have to ask, did he have a firearm at the time he punched the first time? Did Mr. Edgecombe have a firearm on his person the first time he decided to punch Mr. Clearman? Of course he did. Of course he did. If Mr. Edgecombe was a cold-blooded killer, why not take the gun out at that point and shoot at that time? Why? Why not? He was upset. And again, we said at the beginning and opening there's no justification for punching anybody. Mr. Edgecombe should have called the police, let the authorities handle the situation. He should have done that, just as the Clearmans should have done so as well. The state asked Mr. Edgecombe yesterday, they said, when you came down that stairwell, did you know it was a police department right there? Did you know it was a local police department right there? You know when they were grilling Mr. Edgecombe? When he was nervous? The same question applies to the Clearmans. Actually, the Clearmans would have gotten there faster because they had a vehicle to get there. They could have used the same vehicle they turned to go after Mr. Edgecombe to go to that same police station that the Attorney Huebner came up and asked Mr. Edgecombe about. Could have went to the same police station, but they didn't. And that's, members of the jury, are why we're here today. They didn't. Nothing stopped the Clearmans from taking a. How did Mr. Edgecombe get apprehended? They did great work using video to track him down. Just like they are tracking him down for a murder case, as we're here today, they could have tracked him down for a simple battery case, a misdemeanor, for punching Mr. Clearman. They could have used the same technology to track him down for punching someone, but they didn't. That's key. Next slide. So, Ms. Clearman also, confirmed that, she enabled her husband to pursue Mr. Edgecombe while he was on a bicycle. We just talked about that. She admitted that a gun was brandished by Mr. Edgecombe. She admitted, she shouted out, "He has a gun," but says her husband did not hear her. Why is that important? If Mr. Edgecombe has a weapon brandished, that was his testimony, right? On direct, he talked about it. I had my weapon. He said it was around his waist area. He said, I brandished it. Well, now I know, listen, we know certain parts of Mr. Edgecombe's testimony, you're probably like, okay, it's some part that, especially in cross, that, is questionable because he was feared. He was scared at that point. It wasn't me talking to him. It was somebody who's trying to convict him of murder. But when Mr. Edgecombe was asked, he said, yeah, I had the gun brandished. He said, I used my left hand and I said, stop, do not come any closer. That came out on direct. The gun was out already. The gun was used to deter conduct of Mr. Clearman, but it didn't work. Even his wife, who loves him dearly, yelled out, Jason, he has a gun. That didn't stop. He kept coming. And ladies and gentlemen, that's why we're here today. Next slide. Two points here. Ms. Clearman admitted that Mr. Clearman got so close to Mr. Edgecombe, this would be invading his personal space. She admitted that her husband advanced toward Mr. Edgecombe. So initially, she testified that she seen her husband walking toward Mr. Edgecombe, which is fair. She pulled off and she used her vehicle to catch up with Mr. Edgecombe. And then she turns on her flasher lights in the bike lane. You've seen the video. So maybe it's fair that she didn't see a part of the jog as the state has described it. We consider it to be running or hunting someone down. But the more friendly term is jog. But nonetheless, we don't have to talk about words because it's just wordplay. We seen that yesterday. We talked about the testimony of Mr. Edgecombe. It's wordplay. Just words, different ways people describe things. Ms. Clearman described it as advancing toward Mr. Edgecombe. Nonetheless, the evidence now shows that it wasn't it wasn't Mr. Edgecombe who was advancing toward Mr. Clearman. Ms. Clearman's testimony says it was her husband that advanced toward Mr. Edgecombe. That's why self-defense is at play. A cold-blooded killer doesn't run. How many cold-blooded killers run? Cold-blooded killers normally go after who they're trying to kill. That video shows Mr. Edgecombe running. Running, trying to save his life. That's her testimony. Next slide. Okay, we talked about that there was a warning first, then the gun, she touches. So then immediately after the gunshot, you know, she goes to the scene. So immediately after her husband is now on the ground, she gets out of her vehicle and she goes to the scene. Now, you've seen the video, and she gets out the vehicle within 6 seconds. And she goes over to the body, she reaches down, and I count it. It's 4 seconds. Count it. When you get in the jury room, go to the video. Now, the defense has actually enhanced the video to try to make it more clear. You're gonna learn Mr. Edgecombe had to give $5,500 to have, you know, Mr. Mark Robinson fly in from New Jersey to testify about enhancing the video, because it's important that you see. This case is about seeing. It's not about just hearing different versions. Thankfully, we got A-class evidence in this case. Men lie, women lie, video does not. You got permission, members of the jury, to believe what you see. So what she kneels down for, we don't know. She testified that she placed her hand on her husband's back to see if he was alive, then she ran back to the car. Very possible. We don't know. And neither does the state. We don't know. But that was her testimony a year and a half later. You know who didn't ask that question? The Milwaukee Police Department, when they were investigating this case. She was never asked. Why did you go out the first, why did you go the first time? There's no record of that. Now, we later learn, and we'll get into that later, that she goes a second time. Again, she retrieves, they don't say. She makes a 911 call, and she testified that she wasn't able to remember her PIN code initially. Very possible. Again, it's a traumatic situation. That's very possible. It's your mind, I can understand your mind not working the same, but so that being the case. However, at the time that Ms. Trotter comes on, she testified. She came right to this stand and she said that between the time that she got back in the vehicle and you see the red SUV come around, Ms. Trotter testified that she was on the phone with somebody. That's the testimony in this case. These are the confines of evidence that you have to consider. We don't know. I wasn't there. I don't know. Either does the state, and that's why we have reasonable doubt, because they can't prove guilt beyond it. You also heard in testimony that she said she wasn't in the car with Denise's boyfriend, who was an off-duty police officer. Then later she says that after seeing the video, she's like, oh yeah, I do remember him. The police officer, the off-duty police officer who came, Ivana's, boyfriend or husband. She's like, after seeing the video, oh yeah. She recalls that. Again, sometimes after traumatic situations, your memory can fade. That's possible. Our point, members of the jury, is that just the testimony is not reliable. That's all. That's it. No blaming anybody. That's reasonable to not recall certain things. Only thing is the state has to prove it beyond a reasonable doubt. Next slide, please. So, you know, she admitted that she did go to Mr. Clearman. Now, this is all before the authorities arrived. This is all before Milwaukee Fire Department, Milwaukee Police Department, anybody gets there. It's just civilians at this point. She testified and admitted that she went back and forth to Mr. Clearman while he was laying on the ground, not once, but twice. Then she admitted to removing a wallet from Mr. Clearman, and here's the question, here's the issue. We don't know when that wallet was removed. We don't know when the wallet was removed. She admitted of taking the wallet. We understand you want a piece of, okay. She said she wasn't interested in the contents of that wallet. Fair game. When was the wallet taken? We don't know. The defense does not know. Guess who else doesn't know? The state. Did the officers or the detectives ever ask Ms. Clearman when she said, hey, I have his wallet, right? And then, remember, Officer During goes to Detective Kirkvold, and he said, I'm Detective Kirkvold, Tyler Kirkvold. And Officer During says, hey, I have her wallet. And he says, did that come up out of him? Go into it's in the blood, the body worn camera of Officer During. It's that video. And he says, did that come up out of Mr. Clearman? He said, I think so. He said, that's a problem. He testified to that on the stand. That's a problem. The other detective next to him said, incredible. So what happens next? At that point, Detective Kirkvold orders Officer During, go find out where that wallet came from. Who got it? So you see on that video, Officer During says, okay. And now he goes and he asks Officer Mahelik, and he says, do you know where this came from? He said, no, I don't know. He said, I think the wife got it. He says, I don't know, or maybe MFD, Milwaukee Fire Department. Maybe they got it. So Officer During is shown on that video going to the Milwaukee Fire Department, individuals that are on the scene, and he says, did you guys get this wallet? And they say, no, we didn't get it. No, we didn't get it. No, we didn't get it. Why is this important? Because that goes, it imputes notice to law enforcement. Notice is now imputed to the Milwaukee Police Department. And now that they know an item has been taken from Mr. Clearman, it has been removed from the crime scene, at the very least, members of the jury, wouldn't you expect them to go ask Ms. Clearman, well, why did you take the wallet? Why? Isn't Mr. Edgecombe entitled to at least understand why an item was removed from a crime scene in which the state is prosecuting him for murder? They don't even ask the simple question. And you heard testimony from a retired Officer Burns who said that would have been standard protocol to ask someone why something was removed from the scene. And that, members of the jury, is yet another reason why we go back to our board here, burden of proof, because it can't prove guilt beyond a reasonable doubt. Too many questions unanswered. Too many questions never asked. Next slide. We have Ms. Stephanie Trotter. She admitted, and she said that it was weird that Mrs. Clearman was going inside of Mr. Clearman's right pocket. And we just talked about, she admitted that when she pulled up, when the two vehicles on the red SUV, when they pulled side to side, in that 1 minute and 34-second video, she admitted that she was on the phone and she was saying, Anna. So she was indicating that she was on the phone with someone. Now, let's go back to the first point. Ms. Trotter testified. We know she was there. We seen her on video before the video cut off. We know she was there. This woman was there. We know that. She called 911 while Ms. Clearman was by Mr. Clearman while he lay there. Ms. Trotter was very specific when she told you one thing, members of the jury. She indicated that Ms. Clearman was doing something with the right pocket of Mr. Clearman. The right pocket. The right front pocket. That was her testimony. The right front pocket. That was her testimony. I didn't make this up. She came on this stand and she raised her right hand like everybody else did in this case. Members of the jury, what was found in that right pocket? The folding knife was found in that right pocket. Let's discuss this issue. Let's just get it out the way right now. Are we saying that she put it in there, this and that? No, we don't know. We're saying we don't know. We don't know what she did with the right front pocket. I don't know if the wallet in the knife was in the same right front pocket. We don't know. They never even asked, when did you get the wallet? The question was never asked. That's why we have reasonable doubt here. If all the questions were asked, if we had the whole video, maybe we would have more information so that maybe the state could get up this ladder to guilt beyond a reasonable doubt. It's not there. Now, the state just said something in their opening. They said, well, Mr. Edgecombe is saying he's seen something in his hand. That's his perception. He believed he seen something at the time. Now, what you didn't see is Mr. Edgecombe come up on this stand and try to exaggerate a situation. He didn't try to say, oh yeah, it would be quite convenient for him to just come on the stand and say, oh yeah, I seen a knife. Mr. Edgecombe didn't do that. He just said, I seen something. It happened so quickly because he had a big right step and then he lunged at me. So he couldn't really determine what was in his hand. That was his testimony. He also indicated that there was a second threat that he perceived, which was the vehicle. The same vehicle that hit him the first time, that knocked him on top of another vehicle, and where a racial slur was yelled out at him. The same vehicle that you saw, members of the jury, almost hit him a second time in a bike lane. Same vehicle. So at the time, Mr. Edgecombe's perception is these two threats. So he's not going to exaggerate something just to make the story sound even grander. He has every reason to, because he's facing a very serious charge, but he took the same oath that every witness did. And he was advised, you don't exaggerate anything. You only tell the truth. So if you only believe that you've seen something, then that's simply what it is. We don't need to exaggerate anything. They still can't prove guilt beyond a reasonable doubt. Next slide. Now, that kind of brings me to, testimony that was provided by Miss Clearman when she said that they were out drinking. And I always mess this name up, so you guys got to forgive me. It's Scaffides or Scaffides, it's one of the two. But they were, wherever they were at that evening, she indicated that she had one glass of wine. And she indicated initially that Mr. Clearman had 3 beers. That's what she testified to. Once I brought out, based off of his size, in a way, he's not a small guy. He's 6'3", 250 pounds. Not a small guy by any imagination. So when we presented the question to her and we said, well, you know, it showed on his toxicology a blood alcohol level of 0.12. And we question now, 3 beers? Now this is Wisconsin. We know, if we know anything about anything, we know about beer. And 3 beers, a 0.12? So then she testified and said, oh, well, okay, maybe it was 4 beers. Okay, maybe it was 4 beers. I don't know. The defense doesn't know. You know who else doesn't know? The state. But their witness testified that based off of that blood alcohol level, a guy with that weight, he agreed that 8 beers was more consistent with the blood alcohol level of Mr. Clearman. And that was at 240 pounds. The autopsy indicated that Mr. Clearman was 250 pounds.
Counsel, I lost track exactly, but you probably have about 10, 15 minutes.
Thank you, Your Honor. Next slide. So then we go to Lorenzo Hernandez. The assignment was to canvass 4 blocks between Houghton and Humboldt. He observed many video cameras going east on Brady Street, including 2 at Gloriosio's. They were all marked on the maps. This is diagonal to Dynamite. Evangelina said during her testimony, this is where the first incident occurred. He stated in testimony, he never was given a follow-up task as the investigation was turned over to the detective. Again, a lack of follow-up. Next slide. Dr. John Black, you know, what John Black essentially, you know, told us, he talked about selfies, and he talked about when you take a picture with a selfie and how, you know, when you focus on the one object, it's only after you actually get the picture, and then you notice some of the other things that might not have been in your perception at that very moment. You know, that's the same thing in this case. You know, so when you're looking at the video evidence, understand that everything might not have been within Mr. Edgecombe's, you know, perception at that moment. It was a heightened situation. It was, you know, obviously it was an intense situation. So again, that's something for us to consider. Next slide. All right, next slide. Go to the next one. All right, so that brings me to the next point. Mr. Edgecombe testified that he had 17 bullets, fully loaded. How many bullets were actually fired? 1. A cold-blooded killer that only takes 1 shot. He never shoots at the vehicle that struck him one time and almost struck him another. He never shoots when he could have punched, when he punched Mr. Clearman. He doesn't shoot then. What kind of cold-blooded killer is that? Mr. Edgecombe testified that is after, you will see the step. You know, the state said, oh, he was just standing there and, oh, Mr. Edgecombe just pulled out the gun and shot him. No. Let's go to the video. Let's scratch. Let's go straight to the fence. Was it 15? D25. Members of the jury, this is the last time the defense will show you this video before you have it on your own to deliberate. There's no doubt, members of the jury, at this very moment, see, we use that word, withdraw. Don't forget that word. Withdraw cancels out the first incident. It makes the first incident, who cares what happened in the first incident? at this point. It doesn't matter. It also doesn't matter, the second incident doesn't matter either, because of the word withdrawal. This video at this frame shows withdrawal. Could we play, Counsel? Stop it right there. Mr. Edgecombe testified to the screeching tires that he heard. He testified to the heat from the motor that he felt on his back. He testified to just the loud noise and shouting coming from this vehicle. He's testified he was fearful at this very moment. Mr. Edgecombe didn't chase after them in the vehicle after he punched them, which he already admitted. He's not charged with simple battery. When you get that verdict form, battery is not going to be on there. If it was, Mr. Edgecombe would have took responsibility for that. He admitted. Continue playing. At this point, stop. Back it up, please. And stop. Right there. That's the key frame of this case. You see that right step? That was the right step that Mr. Edgecombe described. He turned the corner, he made the right step, and he's lunging toward him. And when you heard the evidence, that, that's when the gunshot goes off after he lunged after me, Mr. Edgecombe's trying to describe the time that he believes makes his actions reasonable. The time of when the shot goes off. That's important. Not the, there was some accident, it malfunctioned. No. This was the time that the shot goes off. This is what makes his actions reasonable. This is why this jury should find Mr. Edgecombe not guilty because of self-defense in this case. Same plan. All right, let's stop that video, close it out. Now, Mr. Edgecombe has testified that he goes down these stairs, he goes home, you don't see him for 6 months. Now the state is gonna argue, that's consciousness of guilt. Remember in voir dire, Attorney Ahmad, he came up to the podium and he asked a question to you. He said, how many of you believe that only guilty people run? Remember that question? Only guilty people run. None of you raised your hands. And then the next question that Mr. Attorney Ahmad raised, what other reasons might there be that someone would run? In that jury room, there were several different people. They said, well, somebody could be scared. Somebody could be fearful of their life. Somebody could, especially as an African-American man, like we still have issues in this country. I mean, listen, we talked about the cases. He talked about he believed he was hunted down like Ahmaud Arbery. He talked about the George Floyd and being taken into custody in an unfortunate situation happens like Sandra Bland. He talked about that in his testimony. We still have work to do. Now, the state, he also testified that he set up a GoFundMe account, that there was a GoFundMe account set up, and that he was trying to get a lawyer. Then he said, well, couldn't you just call one of your lawyers? Just because you have a lawyer on one matter, this is common sense. Use your common sense. Just because you have a lawyer on one matter does not impute an obligation for them to accept you on another matter. That's just common sense. He called lawyers. They told him $50,000 to $140,000. That was the testimony in this case. So just having a lawyer available doesn't mean you have the resources to get one. He was scared. He talked about that fear. So the consciousness of guilt stuff, that's a distraction. That's simply a distraction. If he's not charged with, just running. He's charged in this case with murder. If you want to charge him with battery, Go ahead. You want to charge him with obstruction or whatever you feel like the appropriate charge is for not being available or turning yourself in for 6 months, do so. It's not murder. You got video evidence to make that decision on. Thank God for video. Look where Mr. Edgecombe is when there is video. He's still sitting here. That's why he's so nervous on this stand. He thought that the video itself should be enough. You see it with officers all the time. I thought it was a gun. It turned out to be a cell phone. But we understand, it was reasonable fear. Oh, he looked like he was reaching for something. It's the same law. It's reasonable. It's still the perception that Mr. Edgecombe had. Now, I'm gonna wrap this up. Frederick Douglass once said, in a composite nation like ours, as before the law, there should be no rich, no poor, no high, no low, no white, no black, but common country, common citizenship, equal rights, and a common destiny. And here we are, members of the jury, still embarked on that destiny. Mr. Edgecombe has accepted responsibility for his actions. We told you, he wasn't supposed to have a gun. He pled guilty to bail jumping. He took responsibility so that you guys wouldn't have to start your year off having to decide something that he needs to take responsibility for. He punched the guy. If he got charged with that, you're right. He should be charged with simple battery. He fled for 6 months. He provided his explanation for it. It wasn't because of what you've seen in that video. Any reasonable person would be fearful under those circumstances. Those are all true. But ladies and gentlemen of the jury, those are not charges that Mr. Edgecombe is facing. The charges that's going to be on the form that you're given is going to be murder. And a whole different multitude of degrees of murder. You got to go through that. That's what's on your verdict form. And that's why you need to find him not guilty, because they have not proven this case. Mr. Edgecombe is no murderer. He's a very soft-spoken, scared individual. Members of the jury, I want you to look at Mr. Edgecombe.
Objection, Your Honor.
Well, let's wrap this up. We're at about an hour and a half. The jury's had plenty of time to look at the defendant. Let's just finish with a couple sentences or whatever, counsel, and let's be done, okay? Please.
Yes, Your Honor. Mr. Edgecombe is no murderer. What he is, he's a survivor. He's a man who has already taken responsibility for any wrongs related to this incident. But today you decide, is he an imperfect person? The answer is yes, he's imperfect. But is he a violent, heartless, cold-blooded murderer? Absolutely not. Members of the jury, as the great Willie Geary often said, you have the power. You have the power, members of the jury. You can see wrong, and you can make it right. You can see suffering, and you can stop it. Members of the jury, Attorney Huebner is going to come again, another great attorney. He's going to talk about the rest of his arguments. Use your common sense. You didn't check it in when you came in this building. Use your common sense. And if upon doing so and applying the law to the facts, there will be only one just verdict in this case on all counts that have been on that verdict form. And that verdict, members of the jury, is not guilty. Thank you.
Thank you, counsel. You can just move that exhibit, please, and the stake and do rebuttal.